Good evening, everybody. Thank you all for joining us here tonight. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project. Tonight, we will be talking about the Students for Fair Admissions decision and how it might affect employment practices, especially regarding diversity and inclusion. And of course, the manner in which employers practice diversity initiatives, respectful of employees as individuals, is of course an important concern for the Freedom of Thought Project. But I also think tonight it's the modeling of this conversation itself that is maybe most conducive to the broader objectives of the Freedom of Thought Project. You know, we're having this conversation kind of in the shadow of some real ongoing horrors in Israel and maybe some disappointing reaction to those horrors here at home. And it's easy to lose confidence in a baseline of mutual respect and human decency. And it's just actually really lovely to have our speakers here tonight. Vice Chair Jocelyn Samuels and EEOC Commissioner Andrea Lucas. They disagree on many things, and they are not afraid of those disagreements. They engage on the disagreements, and it's something that there are many who maybe don't handle disagreements well, and we don't want the takeaway from that to be that we just avoid the disagreements entirely. I think there is a way to model constructive dialogue, and it's just been a delight to get to know Vice Chair Samuels and of course Andrea, and moderating our discussion tonight is Kate Todd, and her bio is fantastic and is on the FedSoc website, but relevant for tonight's purposes. She has worked sort of across the legal landscape, in private practice, in government, in the nonprofit world. She is currently at a firm that represents a wide range of clients, from large businesses to small consumers, and represents on either side, defense or plaintiffs. And so really can't think of a better person to moderate tonight's discussion. And she is also just a great friend and a great friend to the Freedom of Thought Project. And Kate, thank you so much for being here, and the floor is yours.
Thank you, Alita, and thank you to the Federalist Society, the Freedom of Thought Project under your leadership for hosting this program tonight. It is designed, I'm going to be a little repetitive because I think it's important, it's designed to be a genuine discussion with civil disagreement and perhaps, I suspect, a little bit of agreement now and then on an important and timely topic. And of course, we couldn't do this without two willing participants. As Alita said, we have Vice Chair Jocelyn Samuels, who's a Democrat, Commissioner Andrea Lucas, a Republican. Both have extensive experience in the employment and civil rights law area. Both have also very generously given of their time to talking about the issues that are important to their work at the Commission, whether that's to the press, in publications, or fortunately for us, in a forum like this tonight. So thank you to you both. I'm going to give the briefest of headlines to the case that's bringing us here, just so we have a backdrop. And that's the Students for Fair Admissions versus Harvard and versus UNC. And I'm confident that there is very strong feelings about the decision and the several separate opinions by everyone on this stage, and I'll say myself included, and probably many of you in the audience, but that's not really the point of this conversation. The point of this conversation is to ask whether that decision impacts the way that employers should be thinking about DEI initiatives, and obviously how that impacts employees and potential employees in the employment context. So I'm going to use as much as possible the court's own words, but I'm going to avoid air quotes and saying the word quote, so I'm pretty close to text. In the court's own terms, these cases, which were brought under Title VI and the Equal Protection Clause of the 14th Amendment, involve whether a university may make admissions decisions that turn on an applicant's race. The 6-justice majority said they may not, that the school's admissions program violate the Equal Protection Clause and therefore also Title VI. The court subjected the school's programs to strict scrutiny and held, the interests the schools view as compelling cannot be subjected to meaningful review, nor is there a meaningful connection between the means they employ and the goals they pursue. It also held the school's admissions systems fail to comply with the twin commands of the Equal Protection Clause, that race may never be used as a negative and that it may not operate as a stereotype. And it held the programs also lack a logical endpoint. I encourage everyone to read all of the opinions in full, to not cheat on this one. But I really just want to start into the conversation and kind of picking up on the theme, and I promise we're going to get to the meat of the discussion in employment law in a moment. But Vice Chair Samuels, I understand this is your first time speaking at a Federalist Society event. And both of you are giving of your evening to come and talk about this important topic. And I'd love to just get a sense of why you thought it was important to do this program in this forum. Maybe you, Vice Chair, you?
Well, thank you very much for the opportunity to talk with all of you. Thank you, Alita, for organizing this panel. Thank you to Andrea for inviting me to be a part of it. I did have to fortify myself with some wine. So just don't throw anything at me, okay? Look, I think this is a critically important topic, and I suspect all of you in the room agree, and I know that Andrea does, because we've spoken a lot about it. The decision has potential implications in the employment context, and so it is important to us in our role as EEOC Commissioners to really think through what are the legal standards that will apply to evaluating employers' DEI initiatives. But it's also from a more policy-oriented perspective, a real question about how we should deal with the history and the continuing persistence of racial discrimination in the country. And I have a lot to learn from all of you. I love the concept that Alita mentioned about civil, respectful dialogues and an opportunity for those who may not agree on legal standards or policy outcomes to nonetheless listen respectfully to each other and learn from each other, because I really want to understand what I suspect are the concerns that many of you in the audience may have about some of the ways that employers are acting to diversify their workforces. That will help me to grapple with questions that demand attention and to be more thoughtful in my own positions. And of course, if I can bring any of you over to my side of the debate, I'll treat you to a glass of wine at the cocktail party. I guess the final thing I'd say is I think I can speak for Andrea, and we agreed that we could call each other by our first names since we see each other every day. We really, I think, are committed to the kind of bipartisan dialogue that the Freedom of Thought Project encourages. And I think we've been successful in having continuing, insightful, respectful dialogue that has sharpened each of our analyses and created a friendship that enables us to do this. So, thanks.
Thanks, Jocelyn. I'll echo a lot of the same points. I think it's so important to form friendships on the other side so you can share perspectives and talk about topics that sometimes can become third-rail topics in society. And that's why I'm really delighted that we're talking about this today. And I thank you, Jocelyn, so much for agreeing to talk about a topic that for the last 3 years publicly has been very hard for many people to discuss. In the last 6 months, we've seen some change to that. But there's been a lot of discussion in some ways and also not a lot of discussion, a lot of singular discussion on this topic. There's been a national conversation on race and racism, diversity, equity. These are all really, really important topics. As Jocelyn said, we know each other pretty well at this point. We've been talking about this for 3 years in our capacity as EEOC Commissioners and as colleagues and then as friends. And, we're both civil rights lawyers. We both can vouch for the other in saying that we care deeply about preventing and remedying discrimination, and we care deeply about seeking justice. And these are all really important topics for us to be talking about, and they're worthy of debate. And that's what I haven't seen happen really up until the last 6 months. A casual observer even for these topics of our national discussion is that everyone sort of reached publicly a single conclusion. There was only one right answer in the public sphere in terms of America's largest employers, largest institutions. The only answer to this challenging topic was that in response to historical or societal or so-called systemic racism, the only answer was to engage in race-conscious policies. And they were race-conscious policies to benefit only a very specific and limited group, racial or ethnic groups. As a result, a lot of employer policies were basically a third rail for people to discuss. How do you actually engage in this legally? Should you engage in this legally? What are the ways to mitigate risk in this space? Lots of nuanced discussion just didn't happen publicly. It may have happened privately, but it wasn't happening publicly. So I think it's really important that we're having this conversation and we can have a little bit more nuance to this topic and model how to talk about a topic that can be third rail in a way that helps us understand other perspectives. So I'm just really delighted to be here.
Thank you again both for doing this. And I want to push us into the conversation, but in order to avoid the sort of two ships passing in the night, I think it would be useful to kind of lay a foundation and get a sense of what you mean by the terms that are often used in this space. And happy to have either of you, sort of kick us off, but, what do you mean by DEI initiatives? Is that the same or different from affirmative action when you speak about it? Is there something different between race-conscious and race-based, et cetera? What you want to kick us off, Vice Chair Samuels?
Sure. Yeah, and I suspect that there will be points in this conversation where Andrea and I actually come out in the same place. And this may be one that when I talk about DEIA, diversity, equity, inclusion, and accessibility initiatives, I mean the panoply of things that employers do to ensure that they are identifying and eliminating barriers, that they are creating inclusive workforces for workers of all demographic characteristics, and that they are deriving the benefits, which I think the Supreme Court has acknowledged exist, of having diverse perspectives in the workforce. I think a critical difference between DEIA and affirmative action, and by the way, I should have said at the outset, I'm speaking only for myself. You are all probably aware the Commission has not issued policy on this question since the SFFA decision. So what I'm representing here are my views as one of 5 commissioners and not speaking for the Commission as a whole. But to me, the difference, the critical difference between DEIA and affirmative action initiatives is that difference between race-conscious and race-based considerations. So the vast majority of DEIA measures are race-conscious in the sense that employers are aware that they may in fact help to address underrepresentation in the workforce or create more inclusive, supportive workplaces for employees. And that may well be part of the reason that employers undertake these initiatives. But they do not take race into account in individual employment decisions. And I think that category of actions where you consider race or gender or another protected characteristic as a factor in your hiring or promotion or bonus or assignment decisions is what I call affirmative action. And I think that that is subject to a different legal analysis. I think it can be permissible under Supreme Court decisions that go back to the 1980s, 1970s, in fact. But it is a different set of measures that demands a different application of legal standards than the vast majority of DEIA work that is done in a way that benefits the workplace or applicant pool as a whole, but does not disadvantage any person on the basis of race with regard to a particular employment decision. But I don't know if you share that view.
Yeah, I think functionally that's right. I think practically speaking, many employers have lumped everything into one big bucket. And it's really important to break it down, right? I think it's, on the one hand, you might say, okay, all of these diversity programs are fine. On the other hand, you might say, post-SFFA, clearly everything is out the window. Neither one of those are accurate because you have to talk about each specific program you're talking about. A couple things that we're not talking about. We're not talking about general EEO, equal employment opportunity policies, as in, here is my anti-harassment guide and policy and training. Here is my anti-discrimination policy guide and training. Those have been around for decades. We are not talking about those. What I think most critics of modern DEIA or DEI or diversity programs are concerned about is the E part in DEI, the equity part. And so, yes, on the one hand, you could say there's a difference between something that doesn't base anything on race and something that does, and that latter camp is affirmative action. You're entirely right, I agree with that, but it's very rare today for an employer to actually come out and call that race-based or sex-based policy affirmative action. The occasional employer will say they have an affirmative action policy, but for the most part, they're just going to call it, this is in their ESG or their DEI policy. They'll have a whole report on it, and they're never calling it affirmative action. If they called it affirmative action, they'd be honest. And then we can talk about whether or not it's justified and whether or not they've actually met it. But for the most part, I see employers really just lumping it all together. So, I think it's really important when we're criticizing something or championing something, what policy are we specifically talking? I think that's where we can end up having a discussion where you take the position that most DEI policies don't involve race-based decision-making, and my perspective is actually most prominent ones that are getting all the press do take these protected characteristics into consideration. That's why there's the debate and discussion about that. Some of it is a definitional discussion.
I mean, I think that that distinction between what I call race-neutral mechanisms, which may be race-conscious because they are undertaken, at least in part, with an eye toward addressing underrepresentation of different groups in the workplace. I don't know where I started that, but anyway, I think that those are different from the policies that were at issue in the SFFA decision. And that's why, and I think Andrea probably agrees with this, I would say that decision does not have direct impact on the legality of DEIA initiatives, and what was legal in the employment space before the SFFA decision continues to be legal. What was unlawful before continues to be unlawful, because what the Supreme Court was talking about was universities that took race into account in admissions decisions. So that is what I would call affirmative action as applied in the employment space, where you are actually using race as a factor to divvy up slots. In that case, in the entering class of Harvard and UNC, in the employment context, it's with regard to hiring or promotions or other job opportunities. The court used the term race-based, I think, 40 times. They weren't talking about these race-conscious but neutrally executed mechanisms. And in fact, there's lots of precedent from the last number of decades where the court has recognized that it's permissible for entities to do things for race-conscious reasons as long as they are executing them in ways that don't result in individual disadvantage. And so that's why I think a lot of what employers are doing now is very likely to pass muster, because if it is things like adopting mentoring programs where you allow whoever wants to participate in a mentoring program to do so, or you do data analysis to evaluate the impact of your employment decisions and make sure that you're not even inadvertently creating arbitrary barriers that can't be justified. Those kinds of things, I think, are perfectly permissible. And in fact, with regard to selection criteria, as you know, under Title VII, they're required because disparate impact theory, as interpreted by the Uniform Guidelines and the EEOC for decades, requires employers to evaluate whether their selection procedures have exclusionary effect, which is something that mandates the kind of race consciousness that I think the court has accepted and blessed in a variety of contexts.
But I think that's the perfect example of where the description of the court blessing race-conscious decision-making really is missing the boat here, right? What are we talking about when you do a disparate impact analysis? We're talking about a privileged analysis conducted by lawyers and HR professionals and never allowing a manager to see any of the demographics. It's kept to an extremely small number of people. You're not going to let the manager who's deciding whether or not to promote someone or hire someone or interview someone know any of those information. It's solely done to either remedy or prevent discrimination. That's not the game here. That's not what people are concerned about. Do the privilege analysis. Do all of them. You're required to. I agree. That's the state of the law. The question is, can you have race-conscious action for managers, for decision makers? That's just so materially different, and the court's never blessed that. Except, obviously, in the limited Weber and Johnson affirmative action program, but that's when you're calling a spade a spade. You're saying, yes, I'm taking a protected characteristic into consideration, and here's why I get to do so, and here are the very, very, very limited situation in which I can do so. But employers aren't calling spades spades. And so that's my concern if that's a red herring for the discussion in my mind, because the bulk of what we're seeing, right, you've got these aggregators, diversity indexes, how do you rank, et cetera, and all of the diversity policies that these types of indexes have, and I'm not going to name and shame, but they're out there and they're easy to find, right, and how they rank someone about where you are for your diversity policies, the things that they are pushing and ranking you on and giving you a higher score, which affects your ESG ratings and affects your all sorts of things, financial, borrowing against your own credit model, a host of implications. People put them in their ESG reports for their investors. Those types of policies that they are pushing for the diversity ones are not just race aware. They are race-conscious, race-based motives. And they're typically things like, do you tie your executive compensation to achieving or hitting certain diversity goals? Do you have diversity goals? And specifically, are those goals matched to the American public, not to your labor market, but to your customer base or to the general population? Do you have race-restricted or sex-restricted mentoring or internship or fellowship programs? You can kind of tick through all of the ones that I find most controversial, and those are the ones that the sort of powers that be that rank people on whether or not they are actually achieving results in the diversity space. Those are the things that are being prioritized. So that's my worry. I think all the other stuff that might be done with the motive of hoping to raise certain votes isn't really what people are pushing hard on.
So I'm glad that you raised this question about goals, because I do think that understanding what we mean by that term is important. And to me, there is a significant difference between the notion of goals and quotas. And quotas have been unlawful under Title VII forever. And I don't think that there is any employer today who consciously adopts quotas, which I define as fixed metrics that are mandatory, that are not tied to any evaluation of the applicable labor pool or levels of really understood underrepresentation. Goals, I think, can be a very salutary way to evaluate whether you are, and again, sometimes these are inadvertent, but creating barriers to the levels of representation that you would see if the workplace were fully non-discriminatory. They are aspirational, they're not mandatory, and I agree with Andrea, in general, it is safer to tie them to the relevant labor pool so that you are looking at what the expectations should be against a baseline that is qualified people. But I just don't see that there is any real problem with setting for yourself a benchmark of what your workforce should look like if your policies are non-discriminatory. It's a check on yourself. It's not a mandate.
Again, I think that if you have as an internal policy exclusive only to your lawyers and your HR representatives so that you can internally measure how you're doing, low risk, most likely. But when you're publicly putting something out there and you're potentially using a dead wrong metric, it's hard for me to really stomach the idea that that's not a quota. So, for example, what if you see an employer, and unfortunately there's many, so I'm not naming anyone in particular here, and they just happen to have these goals and they happen to exactly track the US demographics. Not any particular industry, job position, particular employer, it's just the US population. Does that cause you any heartburn? And now let's escalate it. What if it's that they want to achieve this in 2 years, not 10?
I know that there has been a lot of press about organizations that have challenged employers that have said, we want to increase the number of women in our management ranks by 20% in 5 years. I'm making up those numbers, but I am aware of those kinds of challenges. And I guess I would say, as an aspirational matter, it doesn't cause me heartburn. And the thing that does create some angst for me is any failure to recognize that those aspirational goals can be achieved by race-neutral means. That saying, we would like to get to this level of representation, even if it's based on general population statistics, it's about the world that people would like to see. And if the way that the company encourages its employees to try to reach this goal is through things like evaluating the impact of their selection procedures, or ensuring that they're casting a broad net in recruiting from unusual sources, as well as from the T14 law schools. Those, I think, don't cause harm to anyone and help a company to really think about the benefits it can achieve by having a diverse workforce. And, I think there have been lots of studies over the years that suggest that diversity, including racial and gender diversity, is good for business. It's something that creates more profitability, offers the opportunity to have a diversity of perspectives on how you solve problems, enables companies to better relate to their diverse clientele or customer base. And I think that those benefits are both important for companies to achieve and can be done in lawful ways. And I agree with you, there's a spectrum of risk. And if you are saying to managers, you will get a $5,000 bonus if your workforce contains X number of people of color or women or people of different religions, I think that's a very risky thing to do. But if what you're saying is, managers, we really want you to undertake efforts to continue to diversify your workforces, so go to recruiting fairs and participate in mentorship programs and do pipeline programs with inner city schools that can help to expose kids who may not understand what it is to practice law to what it's about, I think those are likely to pass muster.
Well, and so this also demonstrates a fundamental difference of views that Jocelyn and I have, not just about the risk assessment, but what underlies this. I think people are all humans are inherently evil, right? I think we trend towards bad motives and bad things. And Jocelyn thinks that people are inherently good, and that is often a really important fundamental difference in terms of conservatives and liberals, and as a result, humans who trend towards evil work at companies which trend towards evil. I just don't believe that on the whole companies are out there looking for this kumbaya end. I think that they want to do what's going to make them money and what's going to decrease their public relations nightmare, and people are going to pick the fast and easy and lazy route. And what is fast and easy and lazy? Just picking people based on their race or their sex to hit a goal so that you get more money. All the things that Jocelyn have talked about that are race neutral and are ways to expand the pipeline, they are super admirable. I wholeheartedly support many of them. I don't want to 100% rubber stamp everything you said, but as a general matter, right?
Not that much agreement.
I think there's a ton that
this
that
is
people
sort of
could
like
be
the
doing.
Supreme Court in Groff, where they said, I don't know if you guys have read this, this is the religious accommodation standard for undue hardship, and they said, we're not giving a rubber stamp to the EEOC guidance, but we think a lot of it is really good, which is high praise from the Supreme Court.
Very rare praise, but yes.
Commissioner Lucas, I don't want to cut off the inherently evil line of discussion necessarily, although maybe. I want to give you a chance to go back, because we just covered a lot of ground beautifully. And I told you I wanted to be a potted plant, and I play that well. But I want to give you a chance to go back to the decision, because you haven't kind of laid out your thinking of how the Supreme Court case should be thought of in the context of when employers are re-examining, thinking anew about their DEI initiatives, how should they be thinking about the Supreme Court case?
Yeah, so I'll start with some agreement. Like Jocelyn, I think that as a direct legal application, the court's decision applies in the education space and not the employment space. The reason that's not good news, right? It's a good news, bad news situation. Good news, the law didn't change. Bad news, if you were using the wrong standard, you're really screwed now. My deep concern is that many employers looked at the education space and looked at the stamp of approval for diversity as a tipping point or a plus factor or a soft factor or whatever, or even explicitly diversity as something that was permissible to justify taking race-conscious decision-making in a university applications, and just ported that right over to employment law. And the reality is that that's never been the case in employment law. So nothing has changed. You still can't make race-based decision-making as the general rule, absent a very limited exception in Weber and Johnson. The general rule for almost every single situation is that you can't engage in race or sex or other protected characteristic-based decision-making. So if you've been following those guardrails, you're fine. But if you aren't aware that those were the rules, then I think that you're in a risky situation. And I strongly suspect, based on extensive amounts of looking at employers' policies, both previously as a management lawyer, helping clients consider how to craft these policies, and now as an EEOC commissioner, I think lots of people really mistook what the state of the law was. So it is very much bad news, because now I think there's no question that the court is going to be continuing on this race-neutral path, right? Prior to SSFA, I think some advocates, some commentators wondered, would maybe the Supreme Court accept the diversity rationale in the university space as well as in the employment space? Would we perhaps broaden the Weber-Johnson exception? Would we perhaps allow diversity to be a reason alone to justify a race-based decision-making? Clearly, this court has foreclosed that. The majority opinion, Thomas's concurrence, others, it's very clear. The current composition of the court is never going down that path. And so I think that changes some legal risk assessment. And then practically, I think it affects things because it's a real wake-up call. You can't rely on a commingling of standards anymore. You really have to go and look, what is the state of the law in the employment space, and the state of the law just simply isn't as friendly to, I think, what many very popular employment practices that have come and risen in the last 3 years or so. It's just the state of law is, many of those policies are quite high risk.
It's sort of interesting because I think Andrea used a legal term of art, that employers are screwed if they are. And I would say I do think that employers may be screwed if they overread the SFFA decision, because I think fundamentally, and this is, we may have a difference of opinion on this, I think that DEIA initiatives should be encouraged to the extent permissible under the law, because I think that they create business benefits that I discussed before. I think it is a way for employers to keep themselves out of trouble for being sued for straightforward, invidious discrimination, because it enables them to identify practices that are erecting barriers. And I think there's a moral case for it, because we are still seeing the continuing repercussions of race discrimination, historical and current, in the workplace, of levels of underrepresentation, pay disparities, and things like that. So I think, particularly when it is done in ways that do not disadvantage anyone in the workplace, these are initiatives to be encouraged. And my concern is that too many employers are going to walk away from this and say, it's too legally risky. The Supreme Court is obviously shutting down this whole area of endeavor, and so we're just not going to do it. And I think the consequence of that is going to be a persistence of barriers that may subject them to liability, as well as the loss of the advantages that I think these initiatives create.
I'm glad you brought up the moral case, because as I was preparing for this and thinking about this, I read lots of Justice Thomas stuff. You should, as Kate mentioned, read all of the opinions in SFFA, and please read the Thomas concurrence. It's amazing. But I was going all the way back to some of his...
And the Jackson opinion.
Read that too. Read them all. But I'm partial to the Thomas one. I will admit that. But I was reading some of Justice Thomas's essays when he was chair of the EEOC, which most of you, I'm sure, know. But he's been writing some of these things for decades, even before he was on the Supreme Court. And he had a very interesting essay called "Civil Rights as a Principle versus Civil Rights as an Interest." Sort of the start of his discussion about civil rights as a moral case, and how do you view that as a conservative? And this is a very important thing. So I do want to circle around this topic, right? I agree with you. Civil rights is a moral issue. Justice is a moral issue. Diversity is a moral issue. We should talk about those things, but it's not just one side, right? We hear a lot of discussion about these issues as a moral issue from the liberal side. That's admirable. But young people, law students, everyone should be thinking about this from multiple angles. And as a conservative, there's a moral case for equality, and that needs to be made more crisply and more often. And I think we miss a lot. And Justice Thomas very nicely, critiqued this. He said, conservatives fail not because we lack commitment to equal justice under the law, but because we do not present our case for civil rights at the highest possible plane. So what's a good and just civil rights policy? What's a good and just diversity policy? It's one that promotes individual rights. It's one that produces individual equality. It's not based on group rights. It's not measured by group rights. It's measured, does each individual treated as an individual in all of the wonderful ways and all of the diverse ways that it makes an individual, not just based on their racial classification, not just based on their sex classification. Who are they as an individual? And when we achieve equal opportunity, we're achieving some of the best and most wonderful things about America's promise. That is wonderful, but equity is not the only way to get there. Equality has a moral case for it. And I think that's just so important to talk about it. So yes, I hope that employers do pursue diversity, but I hope that it's individualized diversity. I hope it's not the lazy, old, easy, simple diversity that's just paint by numbers, check a box. What does the aesthetic of the room look like? Is my employee profile or picture on my website pretty enough? Have I hit all of the racial groups? Is it visibly obvious that I have some sort of aesthetic diversity? That's lazy. That's lazy. It doesn't tell you anything. It might actually produce a ceiling for people of racial groups. It may miss any number of people who actually have been underrepresented or historically marginalized, but don't fit anything in some sort of easy bucket. And as America diversifies, it's going to exclude so many people by looking at things from really, really black and white binaries, right? America is increasingly very, very multiracial. We're going to have many biracial employees in the workplace. We're going to have people who are outside of just the gamut of just black or just white, and employers that are only looking at this in that very simple, high-level buckets are going to miss lots of true diversity. So yes, employers should continue to pursue diversity, but it should be an individualized diversity. It should be diversity that looks across all sorts of aspects: socioeconomic status, regional diversity, viewpoint diversity. If they're interested in diversity, that's really the only, I think, way to actually get the gains that some of these studies have said in terms of what's good for business. I'll also say, separate and apart from whether or not it's good for business, equality-based diversity is the moral thing to do because it recognizes our individual dignity under law and under God as a moral case. Like, this is just the inherent reality. So That's why employers should pursue diversity, whether or not that actually gets them $1 more. Right? It's the right thing to do to treat people as individuals. So I don't want people to run away from every single DEI policy. I'd strongly encourage them to drop the equity. I don't think they need the E here. I don't think they should be using that word because I think it gets tremendously misunderstood. But diversity policies that enthusiastically pursue equal opportunity and remove artificial barriers, I'm all for them. And that's why I think this kind of conversation is important, because we can try to, from a bipartisan manner, talk about, okay, what are those things and how could we go about that so that we don't have knee-jerk reactions in either direction.
So a couple of thoughts, and I don't want to cut you off. I mean,
No,
you're an attractive
I have no purpose here. Please, go ahead.
A couple of thoughts. The first is, I don't disagree that employment discrimination law looks at the individual, and you have to show that someone has been subject to discrimination. I also agree that multiple forms of diversity are really critical, and I think that employers should consider a host of factors: socioeconomic status, geography, first-generation achievements, etc. And I think that a holistic diversity policy is the kind that will enable employers to realize the benefits of the business case, and also represents, as you say, a respect for the characteristics that people of whatever race, national origin, sex, etc., bring to the workplace. I guess I think that's not inconsistent with also recognizing that there remain really systemic barriers based on race, and we see it across endeavors, whether it is with regard to achievements in school, or housing segregation, or ability to get loans, or arrest records and conviction rates. It is, I think, palpable that there are still race-based inequities in numerous aspects of societal endeavors. And I don't think that, and those have real repercussions in the workplace. I don't think that employers are disempowered from being able to try to address these things in ways that do not inflict harm on any other individuals in the workplace. And let me just say one thing about equity as well. And I know that for those of you who've read some of what Andrea has written on this, I know that you distinguish between equality and equity. And I actually think that equity, I wonder if your definition is equal outcomes in a way that mean certain levels of representation in the workplace of different groups. So people of particular races or national origin have to be represented at certain levels in order to achieve equity. That's not the way I define it. I think of it as recognizing that to create true equality of opportunity, you have to take people where you find them. And, just as a couple of examples, like the ADA has an accommodation requirement. The Pregnant Workers Fairness Act, which became effective in June and on which we issued a proposed regulation in September, requires accommodations for pregnant women. I don't find those to be a violation of the equality principle. I think that they are recognitions that people's circumstances require different responses and different supports in the workplace because of the needs that they have, and to enable people with disabilities to have truly equal opportunity, you you have to have an accommodation obligation so that they get the support they need that people without disabilities don't necessarily need.
Well, I think that's a great, again, distinction though, right? I mean, pregnancy, religion, and, which is a little less applicable here, but pregnancy, religion, and disability all have express accommodation requirements. They all expressly in the statute require affirmative action. That's not the case for race. It's not the case for sex. People who aren't employment lawyers often have no clue, but there is no bona fide occupational qualification exception for race. It's just not something you can do. I come across very smart lawyers all the time who are experts in their field, and they just don't realize that there's no BFOQ for race. So it's just a different scheme. I will also say, why have we as a society decided statutorily to provide for affirmative action and an affirmative requirement in terms of an accommodation obligation for pregnancy or for disability? And that's because we've concluded that there's the nexus between the additional need is so tight that we are going to do that, and we wrote it into the statute. We didn't write it into the statute for Title VII. We're talking about race or sex. Why? Because we don't think that those immutable characteristics are close of enough of a nexus to automatically assume disadvantage. And I would also say equality, the way you've defined equity sounds like equality sometimes for me, right? Equality isn't treating any person who walks across your door exactly the same. It's treating similarly situated individuals the same. So you don't pay a manager the same amount that you pay a frontline worker. And you don't pay someone who has...
By the way, I just have to interject to say you don't pay a commissioner as much as you pay their special assistants.
We are statutorily capped. This is a long-running joke that everyone who works for us makes more money than us, but it's fine. But generally speaking, right, different people in different positions make different amounts of money, and different people with more or less credentials might, and there's a whole host of things that are material in terms of what you might do. And likewise, in terms of the kinds of employment benefits you might provide. If you see an employee is really struggling, regardless of who they are, or what any of their immutable characteristics are, and you think, you know what, you need more help in this area, and you are a promising employee, and if I give you more training, I think you have the chance to be promoted, of course you can do that, even though you didn't provide that training to coworker X. But it has to be made based on an individualized assessment that has nothing to do with protected characteristics, right? You can't say, you just happen to be a woman and therefore I assume you must have more training. Right. Or you happen to be one particular favored racial group, 1, 2, 3, and everybody else, good luck to you. It can be individualized. That's fine.
Yeah, I guess I would just make the case that there is a way in which a recognition of race and the need for race-conscious assessments is built into Title VII, and that's through the disparate impact provision, where the premise of disparate impact is that the employer has a neutral policy. There's no intent to discriminate. It is simply that you are using a criterion like college degree requirements or a test that disproportionately excludes people based on race or sex or national origin. And what the law says is you've got to justify that if you want to use it, that policy. And if there's another way to get there that's less discriminatory and has less of an impact, you're obligated to adopt that too. And I think it's not the same as an accommodation obligation, but it reflects a consciousness on Congress's part that race will have an impact on the workplace and on workplace opportunities that should be addressed, even if the employer is not at fault for the way in which that policy has disproportionately excluded people.
You'd agree that the disparate impact showing is pretty high. It's not an easy thing to show. We're not talking about, there's 8% of graduates of a particular racial group, and we only have 5%. Therefore, we have a disparate impact, right? We're not talking about those kinds of numbers.
Right, and the courts have obviously developed all kinds of statistical tests that they use to evaluate whether it's a sufficiently substantial difference. And the uniform guidelines, which are 50 years old, say you should use the 4/5 rule. I don't think that courts pay very much attention to that at this point in time. So I agree, you need to look at the level of impact, but I think that the conceptual underpinning is the recognition that it's not the employer's fault that people of color have a lower rate of college degree attainment than white people, but it's still the employer's responsibility to really think hard about policies that would exclude people on the basis of race because of those societal trends.
I don't want to cut you off, and if you want to have a quick response, how are we doing this? Are you having people line up, or we're just roving microphones? So start thinking of questions, like questions with a question mark in them, and we want to get a few of those in before the talk is over. But
yeah, a final thought on disparate impact. I think plenty of conservatives have criticized it, and I think there are questions about how fair it is in terms of whether or not we should have adopted that, but that's the state of the law. That's fair. But I also say, when you've got really significant disparate impact, such as to justify something under the current standards, from a moral weight, I would say sometimes you do wonder how much there are unconscious biases, right? That's a term that liberals like to use a lot. But I mean, if you're being lazy and using a college degree requirement to screen a bunch of people out, is there some latent racial bias there, that this is just easier? Or maybe you're just not making an actually relevant employment decision, and that's important to clean up too. So I don't know that disparate impact automatically assumes that particular racial groups or particular sex groups are going to be automatically disadvantaged, and therefore we need to correct for that. I don't know that that's what we should automatically assume is what Congress is baking into the statute from that. I think there's a variety of ways. Anytime I see a really big statistical abnormality, I worry that there might actually be some actual overt racism hanging out there.
I think there are cases where the level of disparate impact does suggest that there is some potential animus that underlies adoption of the purportedly neutral requirement. Of course, there are many, many, many disparate impact cases that involve gender and strength tests that exclude women. And I think under those circumstances, employers actually think that they need some level of strength. And what courts have said is, no, that actually is not what you need. You need people who are at the top of their level of fitness. I just want to say one other thing. Andrea knows I love this case, and it's not a Title VII case. It's a 1981 case, but relevant to there's no BFOQ based on race that's written into Title VII. There is an opinion written by Judge Posner, who was not on my side of many issues, that recognized that a prison boot camp was authorized to take race into account in hiring for a guard position. Basically, under the analysis that there was an operational need for the prison boot camp to ensure that the inmates felt that the guards were going to treat them fairly and were not going to arbitrarily engage in discriminatory conduct against them, because the prisoners were disproportionately black and the guards were almost exclusively white. And so what Judge Posner said was, we've got to have a way to deal with this. The prison camp cannot operate effectively without having some representation of people who look like the prisoners. So I do think that there are judges who've tried to find creative ways around the fact that there's no race-based BFOQ, but that recognize that race can matter and that it does, and this is not based on a remedial rationale or diversity, but on the ability to do the job that the employer is hiring for, and on the organization's ability to meet the organizational mission. So I don't think that that's been picked up in very many cases, and this was a case back from, 20 years ago or so. But I think it was an interesting attempt on Judge Posner's part to figure out, how do you deal with this real world reality that you cannot keep order if the prisoners think that they are being subject to race discrimination?
I know we want to do questions.
Yeah, can I just see, do we have questions? And then I will let you, yeah. Okay, so first question over there.
Let me finish my, three quick points to that. One funny, two serious. One, I sure hope that employees don't view their jobs all as prisons, right? That context I just don't want in employment law generally. Although maybe given that I just said that everyone's evil and employers and employees are too, maybe it's not that inaccurate. But more generally. More seriously, one, Justice Thomas does talk about, maybe it's a majority opinion, does talk about how there is a very limited situation, right, where when you're talking about race in prisons, there may be a very unique, limited situation. So again, I think that'd probably fit more into that space. And then separately, the third point has escaped me. So there you go. You can get off it. But so one serious, one light.
We have a question.
Okay. Well, first of all, I want to thank you for being here today.
Wait, I think there's a mic coming to you.
I have a loud voice. All right. Oh, okay. Anyway, so I want to thank you three for being here today, taking the time. It's been very informative and great conversation, great points have been made. So a couple of things. First, I'm a businessman, unlike probably everybody else here in this room, as a Federalist Society member in the past, but I am not a lawyer. I'm somebody that actually makes hiring decisions for my company, other companies. And we always have sought to hire the best, the most qualified people, because those are the ones that are going to really make a difference for your company. And I have never seen any study, no peer-reviewed study has ever come across my desk that shows that if you try to force people that potentially are not qualified or less qualified into roles, you are not going to maximize profit. You're certainly not going to make anything better for your company, and you're actually going to probably go out of business. And so if I may ask, when is it, because you have to ask a question, so I will. How about the NBA men's basketball teams or the NFL men's football teams? Would they benefit from diversity, from bringing in, like, say, a 5'2", 130-pound Eskimo background guy as one of the players on the team? Would that increase viewership? Would that make the team more successful?
Yeah, I don't think the race in almost any context outside of the prison one, right, it actually has anything to do with business. And that brings me to my third point. So thank you. You've allowed me to remember the third point I wanted to say. What Jocelyn says sounds perhaps attractive, that shouldn't we recognize that people need representation that's going to help? Well, let's flip it the other direction, right? 60 years ago, how horrible that would be. We don't want any women to work in our company because all of our clients are men and they really just need a man to talk to them and to sell to them. Or, I'm sorry, in Minnesota, everybody's white, so we can't possibly hire a black salesman. They can't sell. Right? The EEOC litigates all day long cases that involve harassment or discrimination based on customer preference. You can't do it. Client preference, customer preference, it's not okay under the law. So just because we're suddenly doing it in a benign manner, it doesn't add, or someone's perceived notion of a benign manner doesn't make it more legally permissible. So yeah, I do think I pretty strongly disagree with Jocelyn that outside of avoiding race riots in prison, that race really is what we want to be measuring on. And so in football, it's going to be strength, and there's a variety of other metrics that might be applicable in other contexts. But race isn't it.
I mean, one of the, in response to the questions, one of the things that I would make clear is we are only talking about hiring or promoting qualified people. I don't think anyone on my side would advocate for just waiving your standards so that you can get people of particular races or backgrounds into your workforce. So I agree with Andrea that it's going to be strength and speed, and you know, I am no expert on men's sports, so I don't know what the criteria would be, but I think that you do need to ensure that people meet the qualifications. What I would say about considering race is that given the levels of underrepresentation that have, you know, been pervasive through various workplaces, not all, but various workplaces or at different levels of workplaces, making sure that you are giving a fair shake to the people of color who present themselves to you is a critical thing. But there's another question. I'm taking your role.
So I think both of you basically accepted the distinction between race-conscious and race-based, right? A policy that is motivated by perhaps diversity considerations, but executed neutrally on the one hand, and a policy that actually explicitly takes race into account on the other. I mean, I kind of want to challenge the obviousness of that distinction, because it seems like if an employer said, we don't want to hire any black people, but we're not going to take race into account, we're just going to do all these things that we know have a racially disparate impact on black people for the purpose of reducing black representation in our company. But don't worry, we're not actually going to have a policy in which anyone ever takes blackness into account as an explicit negative. I think that most people would still think that there's something wrong with that. So is the view that that's abhorrent but permissible, or does that distinction maybe, is it more blurry than both of you have suggested?
I want to be clear, I don't accept that, like the way you've described that, that's not my viewpoint. I think that race-aware policies pose a significant amount of risk. It's a practical matter, right? And it's almost impossible to design a neutral policy that's coming in it with a really intentional desire to increase any particular racial or sex group and not end up having severe implementation problems, which means then you have a lot of practical legal risk. So I think that if you have, I think maybe what you were latching on in terms of what I was saying is if you have a general desire to increase equal opportunity, which is going to mean that you're going to increase and rise all boats, that's fine. If you're looking for fully diverse, like true diversity in terms of everything that makes an individual, great, all of those things are fine. But I think as soon as you start designing something race neutral that has a very intentional motive behind it, you're going to tip into problems.
Yeah, I guess I'd say, I mean, what you are describing is a situation that is founded on animus. It is a, you know, sort of classic kind of invidious discrimination where the race-neutral criterion is actually a pretext for intentional race discrimination. And what I'm talking about when I talk about race-neutral mechanisms are things like the top 10% plan, which has been accepted from quarters across the political spectrum and judges as well, where what you are saying is, I am aware that if I admit students who are in the top 10% of all of their schools, that is likely to net me a more racially diverse student body, because I know there's a history of housing segregation, and that means that schools are also segregated. When your reason for doing that is to promote the values of diversity, I think it's a different scenario than when you have an exclusionary goal.
I think we have time for one more question, Alita. Yep.
Yeah, hi, thanks so much for being here. This is super interesting. I thought I could ask maybe just a somewhat more specific question about kind of where we draw these lines. So I'm just going to quote from a New York Times article and then ask you what you guys think, and I won't tell you the company. But X company is requiring that women and ethnic minorities account for at least 33% of law firm teams working on its matters. Numbers are not enough, however, under a policy that went into effect on Saturday. Law firms must also show that they, quote, actively identify and create clear and measurable leadership opportunities for women and minorities, end quote, when they represent this unnamed company in litigation and other legal matters. So I, until very recently, worked at a large law firm. What that will mean, predictably and intended, is that the law firms will gerrymander the teams that work with that company on the basis of race. They will remove white associates. They will add black associates. I'm just wondering, where do we put that in the pantheon of equity versus equality versus legality? And I'd love your thoughts.
I'll let you start. You can guess what I think about that.
I mean, look, I can't opine about particular facts. I think that to the extent that employers are insisting that their service providers have a particular racial demographic for the teams that serve them, that's risky. I think that what I define as race neutral is taking steps that are accessible for everyone, or using these kinds of criteria that are neutral, like top 10% plan or first generation, even if you do it with the consciousness that it is likely to enhance racial diversity. I think explicitly saying 30% of our teams have to include women and minorities is a much riskier way to go about serving what may be beneficial goals, but that is a blunt approach.
Yeah, I'll just say that just because your client has asked you to engage in discrimination does not immunize you from liability for discrimination. So I'll end on that point.
I want to thank you both again, and this has been exactly what we had hoped, which is a very civil disagreement with some hints of agreement now and then. So thank you very much.
We'll echo that. Thank you to our moderator and our speakers tonight for joining us. And for the audience, I wish we could keep going for another hour. I will say that Freedom of Thought Project will be rolling out a webinar series to take some of these questions and explore them in more detail. So those of you who have registered for this event, watch your email, and you will be invited to participate in that and have the opportunity to ask all the extra questions that we didn't have a chance to get to.
Will I be invited to
Most definitely. You can't dodge that. So please.
Alita told me that I am her new best liberal friend.
On that fun note, everyone is invited to join us for cocktails and hors d'oeuvres right over there. Thank you all for joining us. Again, we are adjourned.